Everybody, so I understand, just a quick start to this. The talk that I'm doing this morning, so Marius and I kind of reversed roles. So I'm doing the legal side today, and he's kind of done the informative side. So yes, Michelle Cohen, as her office has already heard this talk. They actually requested it from me last month. And from doing it and having the chat with her and her office, we got a lot of very positive feedback, and we realized that this is a very important topic. So that is why I am doing it for the rest of the group this month. So Michelle Cohen and her office, I have no objection if you guys log out. But for the interns from Michelle Cohen's office, please will you guys check back at 11, because then we will start doing the logbook chat, or the logbook session. For the rest of you, welcome to my session for this lovely month of May. And as I said, it was a talk that was requested by Michelle Cohen's office. And, you know, on doing a lot of research and insight to this, I realized that it was something that I thought was very important to do for the rest of the group. So whether your office calls it a disclosure agreement, whether you call it just an agreement that you sign between yourself and your seller or a defects list, it doesn't matter. It doesn't matter what it's called. The importance is this discussion between yourselves and your sellers in terms of anything that is not right with the property prior to you either leasing the property out or prior to you putting the property on the market and selling it. And, you know, there is a lot of contention about this specific subject in the marketplace, but, you know, I believe as Leapfrog, we are not followers, we are leaders. So let us rather be the leaders and lead the industry in the direction that it is going to be forced to go. And it is, as it is right now, it is something that has become an agent's responsibility. Now, the argument here is that an agent's job is to find a willing and able seller or a willing and able landlord, and to match that with a willing and able tenant or a willing and able buyer. And the idea is that is solely the estate agent's responsibility. And whilst I would agree with you, yes, if we go back prior to, let's say 10 years back, I would say 100%. That was the agent's only responsibility. Find the relevant parties, bring them together, conclude an agreement, and obviously for concluding that agreement and finding those willing and able parties, you earned your commission. All good and well. But what has happened is, obviously, with advancement, with changes of laws, with changes of legislation, parts of the legislation have put far more responsibility and liability on the part of the agent to then perform their job properly. So the point of this presentation is, what should we actually be doing right now, and what is going to change specifically when it comes to disclosure agreements or defects list? What is actually your responsibility? Because we can't take this, what I call the laissez-faire attitude. Now, the laissez-faire attitude is kind of like the leave it alone kind of thing, where it's the policy of leaving things to take their own course without interfering. Because as you all well know, and you're going to have a smile on your face, when things go wrong in any transaction, who is the first person that gets the blame? Who is the first person who gets the finger pointed at them for not doing their job properly? Yes, you all know the answer to that question. It's always the agent, of course, because you're always the easy party to take blame, and you're always the party that your clients feel need to accept responsibility for something going wrong. So here's what I'm going to say to you, is that we're not going to adopt this laissez-faire attitude. We are rather going to adopt the attitude of, how can I help you in order to help myself, not always getting the blame for things that I know I did do, but the other parties are not willing to take responsibility of. So what I'm saying is that we need to take responsibility of these defects lists, or whatever you want to call them. You need to start taking more responsibility for them, so that, you know what, should issues arise, and there are many issues arise which come from defects, whether hidden or not, and you're kind of always roped in and then having to sort it out. And I'm going, let's get it right so that in future you are more well prepared. Now, we keep hearing about how agents fall into this Consumer Protection Act. You fall under the Consumer Protection Act. You are held accountable in terms of the Consumer Protection Act, that the Consumer Protection Act governs you in your daily workings. So yes, whilst we have a general understanding of that, let's be more clearer about what specific rights under that act actually impact you as an estate agent, because there are 9 consumer rights, but not all 9 are actually valid and relate to you as an estate agent. So there are 3 specific consumer rights which are aimed at estate agents. So consumer right number 6 states it's the right to fair and honest dealing. And that is the customer's right to protection against unconscionable conduct. So yes, as estate agents, we have to be fair and honest in our dealings with our customers, and the customer has the right to seek protection if they feel that that estate agent did not act with honesty, integrity, and fairness. So that's the first thing we need to understand about where it is that you could personally be held accountable in terms of the Consumer Protection Act. The second one is consumer right number 7, which says the right to fair, just, and reasonable terms and conditions. And it's the customer's right to protection against unfair, unreasonable, or unjust contract terms. Now, if you say to me, well, Michelle, where is that going to be relevant in terms of my disclosure agreement or a defects list? Well, here's where it does become very relevant. Is part of that disclosure or that defects list, whatever, as I said, whatever you call it, it's fine, is that does or should be, and I'm going to quote the law, where it should be part of any agreement that you sign. So whether it be at mandate stage or whether it be at offer to purchase stage or contract stage, that defects list does become part. So in terms of just and reasonable terms and conditions, there are terms and conditions in the contract that specifically relate to the defects list that you would have had to have completed with your client. And if you're not explaining those terms and there's not an acceptance from all parties as to full disclosure about the property, yes, they can come after you in terms of consumer right number 7. Consumer right number 8 says the right to fair value, good quality, and safety, and it's the right to demand good quality service. Now, whilst we know we go out and we practice and try to give our clients the best quality service that we can, clients are very quick to forget how much you've done for them, but they're very quick to point out what they feel you didn't do, especially when it becomes the issue of what I call damages or non-disclosure in terms of a property. And therefore, they're going to forget everything, all the good that you've done, and then they're going to come after you and go, well, this is your fault that this is now going to cost me money. Or you need to sort it out because this is something that I feel you should have been responsible for. So those are the 3 rights that specifically estate agents fall under. But I'm going to read a section 40 of the Consumer Protection Act to you, which shows you in terms of your responsibility under the Consumer Protection Act, your exact liability, and it does become your liability and your responsibility in terms of the Section 40 of the Consumer Protection Act. So, very clearly states the obligations contained within Section 40 of the Consumer Protection Act, where property practitioners are expressly prohibited from marketing properties if a full discovery and inquiry of defects have not been made, and where the lack of inquiry could be treated as fraud on the part of property practitioners. Buyers or consumers are the services delivered by property practitioners, and after all, make their decisions whether to buy or not based solely on the information supplied to them by the property practitioner. So, okay, Cornelia, I am going to get to that, so I will answer that question for you further on down the presentation. So Section 40 of the Consumer Protection Act already places the obligation of the estate agent to do a full discovery and inquiry of defects, because it clearly states under Section 40, should the agent not be able to prove that they have done that, then the liability falls on them and could be treated as fraud in terms of you going to being taken to the consumer tribunal in terms of not practicing ethical practices under the Act. So the first act that does become very, very relevant to us currently in terms of our liability and responsibility on that defects or disclosure agreement is under the Consumer Protection Act. So we cannot take that laissez-faire attitude where we think it's going to go away and it's going to resolve itself. No, unfortunately, that is not the case at all. So let's just go right back to the very beginning. Let's see, what is it that we are responsible for? What is it that our seller is responsible for? And therefore, all we can do is ask relevant and appropriate questions. And as we all know in this industry, buyers are liars and sellers are worse. Okay, so let's talk about the first one, which is the latent defect. So obviously, the latent defect is a defect or a fault in the property that cannot be discovered reasonably through an inspection of the sale. So it's something that is not clearly visible, or it could have been visible, but your seller has covered it up, and therefore it no longer is visible. So in the instance, let's just use an example here. In the instance where there was damp in a property, the seller knows they're going to put it on the market. They get a painter in, they put a little bit of a sealant on it. They don't really treat the actual cause of the damp, but they do repairs, they paint. So when you walk in to view and look at the property, that defect is not visible because it has been covered up. So you were not aware that it was there. So the latent defects refer to the hidden or dormant defects. And as we all know, they are the more contentious ones because they often require a trigger to bring it to the person's attention. For instance, roof damage that only becomes obvious after a bad storm. So let's just look at your responsibility in terms of latent defects. Nowhere in any act or any law is it going to say that an estate agent will be held liable for not disclosing a latent defect. However, the responsibility in terms of that defects list, or whatever you want to call it, is that things that cannot be seen, those questions need to be asked by the agent to the client. If your client lies about it, you cannot be held liable for that. The only thing you can be held accountable for is, did you ask the question? So the patent defect is where the responsibility of the estate agent comes in, because your patent defect is the visible defect or apparent defect that is discoverable through reasonable inspection. So as the Cambridge Dictionary explains it, it says it's a fault in a product or property or a document that could be noticed by careful examination and is usually noticed before a sale or agreement. So the patent defects are the defects that can be openly seen, discovered, or understood to be defects. And we'll run through a couple of those patent defects, because those are now your responsibility when you do an inspection of the property. So as we all know, in our sale agreements, we have the voetstoots clause. Now, the voetstoots clause is that Dutch clause, which is part of South African law and is in any agreement of sale besides the ones that the developers do, because voetstoots does not apply to them. And the voetstoots clause says that the purchaser is buying the property as it stands, regardless of the patent or latent defects. So the clause was brought in to protect sellers in the event of latent defects coming to light after the transaction has been concluded. However, and this is what we need to start making very clear to your sellers, especially Cornelia, I'm going to go back to your instance here, where your sellers have lied to you. If the seller was aware of the defect and covered it up, and it gets discovered and it gets found out that that defect existed at the prior to the time that the sale went through, then that voetstoots clause no longer becomes applicable, because it has been ruled by our courts, it's high court rulings, it's in the statutes now, that the seller cannot rely on the voetstoots clause if he was aware of a latent defect and deliberately concealed or failed to disclose it with the intention to defraud the purchaser. So in the case where the latent defect becomes discoverable after the sale has been done, but it can be proved that that defect was in existence prior to the sale going through, that voetstoots clause falls away. Now, that is a very good clause to highlight to your sellers, especially for you, Cornelia, in your question here, is it's something that we need to make our sellers aware of. Mr. Seller, if there is anything that you have failed to disclose to me on this defect list, please note that should that defect become discoverable, even after the transaction has gone through, and it can be proved that that defect existed at the time of the sale, you will still be held liable. The voetstoots clause will not protect you. So we need to fully understand that, and I think it's important that we now start making our sellers very aware of the impact of that clause, because sellers are under the misconception that because the voetstoots clause exists in our contract, doesn't matter what gets discovered after the sale has gone through, they are not going to be held liable. That is completely incorrect. Recent case law and the statutes being changed has changed that. Tianis, I'm actually going to be having a meeting with Bruce, because the principals that have listened to this training so far have all discussed that your defects list or your seller questionnaire does need to change, because it needs to be brought up to date. So I think that's something that's going to be done on a national basis. Well, it needs to be done, because we've got to become compliant with also new legislation, which I'm going to cover, which is going to actually come in and make this even more of a responsibility of the estate agent, because and for you guys, and that's what I'm trying to do here, is I'm trying to protect you against facing the consumer tribunal, facing fraud charges, and facing criminal charges in terms of the new act that's coming into being. So that's why this in training was so important to do now. Okay, as I said, we are leaders, we are not followers. That's us, leapfrog leaders. Okay. So in terms of case law, so In terms of case law, Silvana, all of your sellers' questionnaires are going to need to be updated. I'm going to try call for a principal meeting to discuss it. So, yeah, because because of the acts coming in now that are going to need to change. But anyway, let's not get sidetracked here. Okay. So in terms of case law says, let's look at what an agent should have knowledge of that they would be held accountable to in terms of a transaction, and what information would a seller have knowledge of that the agent should be asking their client. So in terms of what should an agent have knowledge of? One, area information, very important. You shouldn't be relying on your client to tell you about what's happening on the area. That is research that you would need to do in terms of the area where you're working. Two, any proposed developments. Anything that could impact the price, whether negatively or positively, in the area, the agent should have knowledge of. Crime statistics, very important. There was a case that went to court regarding a property that had been sold by an agent. The specific request of the buyer was they wanted to buy in a low crime area. The agent sold the property to the buyer whereby there had been an armed robbery and there had been a murder next door, also in terms of an armed robbery, and it did go to high court, and the agent was found negligent. The agent's case rested on the fact that crime statistics are public knowledge, and therefore the buyer could have gone to the local police station, accessed the crime statistics, and would have been given all the information. The judges in that specific case law said it is not of the responsibility of the buyer to go and do research. It was the responsibility of the agent, because of the reasons that were disclosed by the buyer as to the specific motivation of buying into an area with low crime statistics. It was the responsibility of the agent to know the crime statistics and to disclose them to the buyer. The other information, which again comes back to our defects lists or disclosure agreements, is the agent is responsibility in terms of the property information and condition report. So those are, and that should be done between the agents and their client and should be made part of the agreement and disclosure to any buyer that anything in that disclosure document could impact the value or the opinion of the buyer as to whether they would put an offer in on that property or not. So anything that would impact the knowledge or the decision to buy or to let has to be disclosed, and therefore that property information or that condition report must be the agent's responsibility. So the courts call this, and the Consumer Council, the Consumer Tribunal, also use what they call a reasonable man test, or what should reasonably be within an agent's knowledge. One, very specifically, that disclosure form. In the disclosure form, they make an allowance for facts that only a seller could know about. So information that the agent should be gaining or should be asking from their client, because it's information that only a seller would know about the property, or a landlord would know about the property, but the responsibility is on the agent to ask the question in terms of that disclosure form. Recent repair work to the pool is one of them. Recent repair work to a leaking roof. Subsidence, flooding problems, latent defects, any planned developments. Genevieve, I'll come back to your question. Any latent defects, any planned developments around the house that he knows about. Now, those are questions which, in terms of the Consumer Tribunal, in terms of all the rulings that they have made, those are facts which a seller would know about, which the agent is responsible to ask. Any arrear rates and taxes on the property older than 2 years. Involved with any disputes with regard to neighbors around boundary lines. And are all improvements on approved plans. So in terms of how the tribunal rules is they go, that should have reasonably been within your knowledge because those are questions that the agent should have asked the seller. I'm going to go back to Cornelia because she goes, what if your seller lies? Here's the thing, guys. You cannot and will not be held responsible if your seller lies to you. We can't control that. However, all you would have to prove if you were called into that tribunal is, did you ask the question? Where was it answered? And did the parties sign? And as long as you can prove that, there can be no liability and no responsibility on the part of the agent. The only liability and responsibility that comes into play is if the question is not asked and you cannot prove that the question was asked, it was answered, and the party signed in agreement to it. So that is why that disclosure and defects list becomes such a critical part of what you need to do with your clients. Okay, Genevieve, the question comes in there, and I'm going to come back to your your answer because it's actually in the code of conduct. So I'm not ignoring you. I'll come back to you. So in terms of the courts and the rulings of the tribunal, they call the reasonable man test. And the definition is, when is an agent going to become or be found to be negligent? And they go, the agent's very clear. The agent will be negligent. So they look at every case. The agent will be negligent when they fail to do something where there was a duty of care on them to do something. That conduct or failure to act results in damages to another person. Such damages could and should have been foreseen, and the agent should and could have taken reasonable steps to avoid this. So I'm going to refer back to one of the cases here where there was a disclosure agreement. It was part of the sale agreement. What happened was the agent asked the seller, does the roof leak? The seller ticked no. The disclosure agreement was part of the offer to purchase, became part of the sale agreement. The disclosure agreement was signed by both buyer and seller. What happened? Buyer moves in, first heavy rains, the roof leaked like an absolute sieve. Buyer, of course, phones the agent and goes, you better come here and have a look. There's absolutely no ways that this seller did not know about the major leaks in this roof. And then what it resulted in was the buyer, as well as the agent, trying to get proof or evidence that those leaks were in existence prior to the sale of the property. And that's the situation we don't want to find ourselves in. And what it was discovered, unfortunately for the agent, is that the seller who sold the property had only actually resided in the property for 8 months. The same agent had previously sold the property from a previous seller who had disclosed that the roof needed major repair and did leak substantially. Now that all came to light when this whole issue happened. And what the court ruled was that in a certain period of time, that the first seller made the agent aware that the roof leaked very badly. The agent did not disclose that to the buyer, And in the time period that the buyer had been in the property, it had not been the rainy season, so was unaware of the roof leaks, and sold the property on a disclosure agreement saying the roof had not leaked. And then what happened? The next buyer took occupation, rainy season happened, and the roof leaked like a sieve. And they went back to the first instance where they said, the question that should have been asked by the agent was, have you made any repairs to the roof from the time you've purchased the property to the short time now that you are selling it? Because the agent was aware in the first sale that because the seller had disclosed it, that the roof leaked. And because the agent hadn't done that, the court found the agent negligent, because it was the same agent in both transactions. And therefore, the court ruled that the agent was negligent because they failed to do something, because that agent knew the roof leaked from the previous seller. That conduct or failure to act, to ask that the seller now, have they repaired the roof, knowing that the roof leaked, has resulted in damages to the new buyer, and such damages could and should have been foreseen, and the agent therefore should have disclosed to the current buyer that yes, not this seller, but the previous seller had disclosed that the roof had leaks, because the agent was well aware of the fact. And that's what they call the reasonable man test. So where a seller lies to you, but you are aware of a fact, you will need to disclose that fact. That is what the court, the tribunal brought to light. And if the agent had asked the current seller the question, have you repaired the roof? And if the answer was no, it was the agent's responsibility to disclose to the buyer that the roof from the previous seller had leaked. It hadn't leaked in the time that the current owner had the property, but they didn't have rainy season, and therefore there was the possibility that the roof did have leaks. And if the buyer, if the agent had done that and the buyer had accepted it and signed for it, the agent would have not been found to be negligent. So that is where it becomes critically important, and where those disclosure agreements or sales questionnaires are becoming more and more important. The new act, which is going to place even more responsibility on you, is the new Property Practitioners Act, which I hear from good sources. They are saying by the end of May, it is going to come into being. And in terms of the Property Practitioners Act, this is now going to be crunch time in terms of those seller questionnaires and those declarations. Because in the new Property Practitioners Act, under clause 10, it makes it very clear. The agent may not accept any mandate to sell or lease a property unless a disclosure agreement has been fully completed and signed. The form must be provided to every purchaser or lessee who makes an offer to purchase or completes a lease agreement. The document must be signed by all parties as an annexure of the agreement, and failure to comply will result in the agent being held liable by an affected consumer. So I'm going to actually just read to you from the specific Property Practitioners Act, and it makes it very clear there. And it's also from clause 10, section 67 of the Property Practitioners Act. And it says, if the disclosure form, now listen to this very carefully, if the disclosure form is either not completed prior to the mandate and a copy supplied to all prospective tenants or buyers, and it is not attached to the agreement, then it will be accepted that no defects were disclosed to the buyer or the tenant. This means that the seller or landlord in a property deal will be completely exposed on defect claims and will have no legal to defend such claims. Property practitioners who fail to follow the rules set out in these sections can be held personally liable for damages on either part of seller, buyer, landlord, or tenant. This needs to be repeated for full effect. If the property practitioner puts the property on the market without a disclosure form completed and signed by the seller or tenant, even if it is done immediately thereafter, it is assumed that the property is sold or let as if no defects were disclosed. Guys, that is going to be a very, very, very serious offense for us. So the sooner we get in the practice of doing these seller disclosures or these defect reports prior to us even putting this property on the market, whether it be for sale or to let, let's get in the habit of doing it now. The other advice that has been given, because a lot of you sell properties where an owner, so let's say the property's been rented out for 10 years. The owner themselves who own it have never taken occupation of the property, or they've never lived in it, or they lived in it a very long time ago. They're out of towners now. They haven't seen or been to the property in a long time. The legal advice in terms of handling that is when you are doing your seller's questionnaire is either to get permission from the owner of the property to allow the tenant to complete the disclosure or defects list or your seller's or your questionnaire. So you've got to get permission though from the owner to allow the tenant to do that. If the owner gives permission, you get the disclosure agreement completed by the tenant. However, the owner of the property has to still sign that questionnaire. The other alternative that has been given is if the owner of the property does not want the tenant to complete the defects list, then a line gets put through the seller's questionnaire and a declaration gets made at the bottom, whereby it states, the owner of the property has not resided in this property for however many years and therefore will not complete the disclosure agreement as they are unaware of any defects on the property, and you need to get both your seller and your buyer to agree to it and to sign it. In that instance, the buyer then understands that then that full foot to its clause will apply and will be held in effect and enforceable, because he is then accepting that he is purchasing the property with all latent and patent defects. So yes, when this act comes into being, it's going to make our responsibility and liability even more so than what it is. Here's the myth that I just want to clear up. The Property Practitioners Act is here to replace the Estate Agency Affairs Act. The Code of Conduct is part of the Estate Agency Affairs Act, but the exact same Code of Conduct, word for word verbatim, is going to be part of the Property Practitioners Act. So the Code of Conduct, as we know it, is not going to change. So in terms of the specific clause which is applicable to us when it comes to the seller questionnaires or defects lists, is the duty to disclose clause. And that's where it says, disclose all reasonable facts concerning the property which should be part of your knowledge and would affect or influence your buyer or tenant's decision. And it goes back to the law where it says, bonus morales, what is good morals on behalf of the agent. So with regards, I'm going to go back to Geneviève's question here with regards to the hijacking. Yes, you have to disclose that fact. I'm also going to bring up the case of because a lot of agents have questioned this before, whereby there has been a suicide in the property, or there has been a murder, or there has been a death. Now, for many different cultures, death signifies different things and has different meanings. For some cultures, it makes no difference to them, but for other cultures, it makes a huge difference. So in terms of disclosing all reasonable facts that are part of your knowledge, yes, those things do need to be disclosed. It then becomes the buyer's discretion as to whether they accept them or they don't. But if we fail to disclose, you are going to be found negligent. So that is really the bottom line. Also under the duty to disclose clause, it makes it very clear that the agent needs to disclose latent defects, patent defects because of our questionnaire, and explains the understanding of the Footstewards clause. So it is there again. So here we've got Consumer Protection Act, Code of Conduct, Property Practitioners Bill still to come into practice. But here we are going to have 3 acts that are making it very clear what your liability is in terms of that seller questionnaire or the defects list or disclosure list. Very interesting case law, which happened in 2015 with regards to defects. So what actually happened here was that many of the defects were visible to the purchaser on initial inspection, and the seller was able to rely on the Footstewards clause. However, one of the defects was with the electrical fence, which needed attention. The seller assumed that the electric fence was working, but it later transpired that the gardener had suffered an electric shock, which led to a security expert performing an extensive inspection on the fence, and the expert found that the fence had not been earthed properly and required certain maintenance. In this instance, in this case law, the seller could not fall back on that Footstewards clause because the seller, it was his own gardener who was shocked by the fence, and therefore the seller was very aware that that fence was not in full working condition. So the court ruled that the seller, the Footstewards clause did not apply, and the seller was fully liable for all the repairs and fixing that entire fence. So just a good example of case law in terms of that Footstewards clause is not always going to be upheld. In terms of non-disclosure, there's 2 types of non-disclosure. There's what we call express misrepresentation. Now, express misrepresentation, I'm going to go back to Cornelia because she did ask the question, is when you ask a seller a direct question. Mr. Seller, is your pool in full working order? And your seller answers, yes, it is, knowing full well that the pool does have a leak. That's what the courts will call express misrepresentation. The problem is, if we don't ask the seller direct questions about potential problems or what normally become potential problems, the seller still has a duty to inform you about any latent defects which they are aware of. And if they fail to do so, it falls under non-disclosure. The problem with the express misrepresentation and the non-disclosure is in both cases, the seller has defaulted. But then it becomes the part where the buyer has to prove that the seller was aware of the condition prior to that transfer going through. And unfortunately, that's where the agents start getting the hard ball thrown at them because they're going, but did you ask the seller? Where did you ask the seller? And that's why, again, that disclosure agreement becomes so important to complete. So let's go back to this reasonable man test. What is it that you are expected to be able or to complete on a disclosure agreement or your seller's questionnaire that you should reasonably be able to see? Any visible damp, any cracks or leaks, You need to make a note of them. Don't rely on your seller pointing them out to you or disclosing them. If they are clearly visible, make a note of them. Any broken windows, broken doors, built-in cupboards. Here's the thing with built-in cupboards. The only expectation from the agent is what is visibly to the naked eye, what is happening inside the cupboards. If the doors are closed, there is no expectation on you to open those doors and visibly inspect the inside of the cupboards. There's no liability to you on that part. It's only what you can see in the open with the naked eye. Broken floor tiles or damaged wooden flooring. If there are carpets covering areas, you need to ask the question. It's to protect yourselves, guys. Any surface or structural cracks that can be seen. Is the gate motor working? If you see there's a gate motor, ask the question, is the gate motor in full working order? Is the guttering in good condition? Are there any specific pot plants that will be removed or specific plants in the garden? Any fixtures or fittings that are not going to form part of the sale? If you live in an area where you had, when I used to work in Grand Park Ridge, there was a few builders who built face brick homes, but the inside was prefabricated walling. Now, a lot of buyers would not even consider those properties because they didn't want the prefabricated walling because it's just it's a preference, it's a choice. But normally the prefabricated or drywalling, it is actually very visible. And all it means is that you just need to knock on the wall it as a test. Or if you can see a garage is being converted with a dividing wall, it's clear to see to the eye, it is something that needs to be disclosed. If the house has air conditioners or fireplaces that are visible, the question needs to be asked, are they fully functional? If there is underfloor heating, again, the question needs to be asked. When last did you use the underfloor heating and was it in full working order? If your seller says to you, listen, they haven't switched the underfloor heating on since they moved into the house and that was 5 years ago, make a note of it in your questionnaire. Because again, you're protecting your seller, but you're also making your buyer aware that your seller's not lying. He just hasn't used it in the last 5 years, and therefore he cannot answer a yes or no question. So what he's doing is he's disclosing they have not used the underfloor heating in the last 5 years. So he's not going to say, yes, it is working, or no, it's not. But the buyer will then accept responsibility that it hasn't been used in 5 years, and the seller is not declaring yes or no. So whatever, if it is working, great. If it's not, unfortunately, then it's for the buyer to sort out. Protect yourselves and your clients. Have there been any roof leaks or have there been repairs to the roof in the last 12 months? Is there any damp in any cupboards or has there been any recent damp repairs? Have plans for the property been approved? Have there been any recent additions or alterations? Has the property been rezoned, and if it has, are they in possession of the certificate? Are all the light fittings, electrical plug points, gas appliances, to their knowledge, are they in good working order? Remember, your compliance certificate, the responsibility on the compliance certificate is to check that the electricity that goes from the main board to the specific point is in good working order. The electrician does not come in and switch on all the plates on an oven or a stove to check that they are working. And that's why you need to ask that question. Have there been any issues regarding plumbing or sewage? Is the pool in working order, and what specific pool equipment will stay? Have there been any repairs to the pool? And ask specifically what has been done. And if your client has answered yes to any of these questions, then the responsibility is for you to ask, do they still have guarantees for the repairs that have been done, and are they still valid? Just a few simple questions to ask that can avoid a lot of issues happening further on down the line. The real questions that need to be asked is the non-visible, the underfloor heating, keys to external and internal doors. Boreholes, are they working? When was it last used? Water systems and irrigation systems, because you can sometimes see they're in the garden, but you don't know if they're in working order. The electric fence, is it fully functional? Now, here's what I'm going to tell you about an electric fence, having my own one on my own property. Unless that electric fence is brand spanking new, then you probably won't need any repairs for the first, I'm going to say 2 to 3 years. But here's the reality. When the electric fence exceeds that period of time, trust me, every single electric fence will have some kind of maintenance done on it every 6 months or so. And whether it just be that the wire's broken or one of the bobbins is broken off because of normal wear and tear. So it's not necessarily damage or someone's tried to break the fence, but it's just normal wear and tear. Trust me, if somebody says to you they have not had to do a thing on their electric fence in the last 5 years, I'm telling you now, reliably, they are lying. Every fence, when it starts to get a bit old, we have very harsh climates here in South Africa. Trust me, those electric fences, things do break and things do go. So then you're going to know your seller is lying, but nothing you can do about it. You just need to ask the question and put the answer down as they've answered it. Is the alarm system fully functional? Have there been any upgrades to the alarm system? Does the intercom system work if applicable? Are the rates and taxes up to date? Important question to ask because it is going to impact the transfer. If the property is in an estate or complex, please can you get a copy of the Homeowners Association rules or conduct rules? It needs to form part of your offer to purchase or lease agreement, and your client needs to be given a copy and is fully aware of the rules. Very recent ruling now, massive high court case, probably one of the biggest of its kind, was against Pam Golding in an estate whereby the Homeowners Association rules were never part of the sale agreement, became a very big bone of contention because the buyer claimed there were specific reasons for them buying in the estate, but there were also specific things that they discussed with the agent they were going to do to the property once they had taken transfer. Once they took transfer and then went on the process to start doing what they needed to do, to be stopped by the Homeowners Association and told that those things were not allowed as they were part of the Homeowners Association rules that were not allowed to be done in terms of the state's aesthetics. Huge case, and the case ruled against the agent from Pam Golding and said, the law says if you are selling in a development or any homeowners association or in a complex where general rules apply, those rules need to be a part of the annexure of the agreement, and all parties have to agree that they have received a copy of those rules. So again, something very important for us to keep in mind. The last thing that I'm going to say to you is, here's what we need to understand about this presentation today, is that a lot of the times clients get very irritable and almost don't want to sign these disclosure agreements or whatever you want to call it. But if we just need to take a little bit of time and explain to all parties that actually what you're doing is you're trying to protect them and you're doing it for their benefit, we probably would meet with less resistance. Because if a person feels they're gaining from having to do something, then they approach it with a better attitude. The gain is that you don't want to create any issues for them further on down the line. Because here's what I'm going to tell all of you, is that we may all think that we are super listeners, but you're not. We've proven that point. So it is absolutely impossible that you are going to remember a full conversation, exactly word for word, verbatim what was said, 3 or 4 months down the line. And then it becomes a situation of he said, she said, and as we all know, the only loser here is going to be you. So when we go, if we've got everything in a disclosure agreement, you've got it in black and white. You can prove it. All parties signed it, agreed to it. You know what? Then you stop getting the bad rap for not doing your job, because you have done your job. And reputation is absolutely everything in this business, as most of you know. And that's what that disclosure agreement is also there to do. It's to protect you in your daily workings, proving that you are doing the best that you can possibly do, but you also are protecting your clients, but more importantly, you're also protecting your reputation in this business. And the most important question is, just remember, always ask the questions. If we ask the questions, we can't be held responsible for who is lying and who is not. Because if we ask the questions, we have to accept the answers at face value. But all we know is that we are getting our clients to sign as to the way that they have answered those questions, because it's also protecting ourselves. Form to request whether we still have any cover whatsoever through. No, we have no cover whatsoever from the EAB for professional liability. You must remember, Ansi, and here's the big contentious issue about the Estate Agency Affairs Board is you pay a professional fee to them every year for your license to practice in a real estate business. So one would think that because that is the body that is representative of estate agents in South Africa, they would afford protection for estate agents in South Africa. Unfortunately, there is absolutely no protection for estate agents. That's the only liability insurance in terms of the Estate Agency Affairs Board is this. If you get taken, if you get reported to the board, it goes to arbitration or it goes to a high court. If there is an awarding of damages, the Fidelity Fund will pay out the damages. However, that Fidelity Fund will come after you in your own personal capacity for repayment of those damages. And until such time as those damages have been repaid in full, you will not be given your license to practice. Or if you are unable to pay the damages, then the courts, they will take an order against you. So basically, you're going to have a judgment against your name. Besides which, you don't really want that to be the case. So all I'm saying to you in this instance is, let's just protect ourselves first and foremost. So let's start being a lot more thorough with our sellers' questionnaires and those indemnity agreements. Let's start being a lot more thorough in the questions we need to ask our clients. As I said, you cannot be held accountable if they lie. You can only be held accountable if you fail to ask the question. So, yeah. Any other questions, everybody? I hope you've enjoyed the presentation. As I said to you, let's be leaders, not followers. Let's start getting these sellers' questionnaires completed fully and properly and to the best of our knowledge. Let's take full responsibility for them, and it's going to assist you in the long run. So when the new act comes into being, it's like, oh, well, who cares? I'm doing it already. So it's no big deal. Have a great May further. Thanks, everybody. Yes, you're quite right, because a lot of sellers rely on that Voetstoots is a fallback for them. Pleasure, everybody. Good stuff. Okay, my interns, I'll give you 5 minutes and then we can